Hi, thanks for watching. Okay, so in this video, I want to talk about Danny Masterson's side, how Danny Masterson and or his attorneys are actually responsible for him having such a long sentence in this recent R case out of California. Okay, so um, it's pretty clear the sentencing range for the type of crime that he committed under the One Strike Act with the aggravating factors. Here we had the aggravating factor of using the drugs, using drugging the victims, and also I think the fact that there was more than one offense. Okay, so there were a few aggravating factors that put him under the One Strike law, and so basically the judge could have sentenced him anywhere from 15 to 30 to life. Okay, so there was an opportunity to sentence him to 15, but I mean, there were some other aggravating factors in the case. Okay, so here's the thing: because he could have been sentenced to much less, you have to ask, why didn't the defense team offer a plea bargain at some point? Okay, knowing the exposure, knowing that he was exposed to such a long sentence. Okay, and then I want to look at the possibility of maybe a conflict of interest, since his attorneys were also sort of I'm not going to say his attorneys were also representing Scientology, but because Scientology had such an interest in this defense, because Scientology was actually involved in some of the actual defense arguments. Okay, in other words, or actually some of the prosecution arguments, because part of the prosecution's argument as to why the victims didn't come forth earlier to report these crimes is because Scientology was involved in trying to deal with this out of court. Okay, so Scientology actually had something to do with the actual merits of the case. In other words, there's a very big issue of why the victims didn't come and present their case within the statute of limitations, within the ordinary statute of limitations. Okay, and because Scientology was involved in trying to settle this matter out of court. Okay, Scientology is actually involved in actually the actual merits of the defense. So you immediately have to ask the question, because Scientology has an interest in this defense. Okay, you have to ask the question if Scientology didn't collaborate and sort of help Danny Masterson finance his own defense. Okay, and maybe if Scientology didn't have an interest in sort of lining up their side of the defense with Danny Masterson's side of the defense. In other words, obviously Scientology has its own attorneys, but because they probably were coordinating with Danny Masterson's attorneys to have sort of a coordinated defense strategy, you have to ask whether there was a conflict of interest. Okay, and maybe Scientology's interest was sort of over dominating and influencing how Danny Masterson's own attorneys were representing him. So you have to ask if all the chain in decision making, as far as whether to try to offer a plea bargain, because maybe Scientology would say, hey, if Danny Masterson offers a plea bargain, that's going to make Scientology look bad. So you have to ask whether there was some influence, and whether Danny Masterson really had conflict-free counsel. Okay, and that's really important, because if you don't have conflict-free counsel, okay, even if you purport to waive it, there could even be a question as to whether he had a meaningful waiver of his right to conflict-free counsel. Okay, and under those circumstances, it's conceivable that he could file a motion to set aside the sentence under California's post-conviction relief system. Okay, and then if he loses that, he might even take it to the federal courts under habeas corpus. So there are some things that can happen outside of an appeal, because you could argue that maybe his counsel wasn't really free of conflicts. Okay, or that Danny Masterson, if he waived his right to conflict-free counsel, you could ask whether he had a meaningful waiver, because if theoretically he could argue that Scientology has such a hold on him and his family that he wasn't really in a position to waive. Let's say his waiver wasn't really voluntary. Okay, because there's so much pressure coming from Scientology. So the whole point here is that I can't really say that Danny Masterson's attorneys were completely free of conflict. Okay, I can't say that, because I don't think they were free of conflict. I think there was a lot of conflict of interest. And I think Danny Masterson's defense may have even received funding from Scientology, or at the very least, there was coordination between Danny Masterson's defense team and whatever Scientology attorneys had an interest in this defense. So because we can't really say that his defense team was free of conflict. Okay, the Sixth Amendment of the Constitution does guarantee the right to counsel, and implicit in that right to counsel, a right to a defense and right to counsel. Implicit in that is the right to have conflict-free counsel. Okay, have counsel that's free of conflict of interest. And then the question is, well, if Danny waived that, and he may have signed a waiver, the question is, given how far Scientology dominates and penetrates families and controls families, basically what would have happened if Danny did not sign, let's say, a waiver of conflict? Okay, maybe the consequences of Scientology would have destroyed his life potentially, you know what I mean, or separated his family. So he could present the argument that he didn't really have a meaningful choice, and so he didn't really have a truly voluntary waiver, whatever waiver he may have signed, waiving the right to have a conflict-free counsel. So basically, I do see issues. Before we even get into the appeal, I do see issues where maybe there's a reason why he didn't enter into a plea agreement, or there maybe is a reason why his attorneys did not maybe press on him the wisdom of possibly entering into a plea agreement. Okay, so I'm sure he had really good attorneys, and I'm sure they had really good arguments and reasons for everything. But a good attorney often will very much press on a defendant that you could be in a much better position if we just go ahead and plea and enter a plea bargain, because you could get a much, much lower sentence, and possibly even only plead guilty to a much lesser crime. Okay. So the bottom line is, I think we all know that Danny did not have to have a 30 to life sentence. Okay. That there were many, many ways that the game could have been played so that he could have had a much lesser sentence. Okay. And my feeling is because Scientology was so infected, I think, in even why the statute of limitations was a problem in this case. And also, I think Scientology was even involved in how this case appeared to be so aggravated. Okay. Because you could say that, early on, I think one of the aggravators was that Danny Masterson had like some of the victims signing non-disclosure agreements and trying to quiet and settle them, paying like private settlements to sort of shut them up, basically. And I think the court took that as an aggravating factor. Okay, that showed that Danny's intent to try to conceal the facts of the case, which is sort of definitely an aggravator. But you could look at that as basically Scientology's influence. Okay, and so it's Scientology is very much connected to all this. And so I guess Danny Masterson, maybe privately, he may not have wanted to be so aggressive with these victims, but maybe Scientology was kind of, sort of, they had an interest in this not getting out early. So the whole point I'm saying is that I think Scientology is very much tied into this, and that if they were, let's say, more out of the picture, okay, I think maybe Danny Masterson's defense team maybe would have said, hey, look, there's a lot in this case that looks very bad for you. Okay, potentially even aggravators. Okay, because of the way you tried to quiet these girls, way back when. So I think a good defense attorney would have told him, look, because there are some aggravators in this case, potentially. I mean, we'll try to get this evidence suppressed, but because there are aggravators in the picture, okay, you might be in a better position just to settle this. Just to settle this with a plea agreement. Maybe we could plea down to maybe some very minor form of, sexual battery or whatever. The most minor form we can possibly get, just to get the state, to save its resources and just to agree, to a guilty plea and maybe a little bit of prison time, but at least you get to have your life, basically, So, I mean, Danny Masterson's team also played the cards. They also rolled the dice. And maybe the reason why they rolled the dice in part was because Scientology didn't want to look bad. Okay. And had Danny Masterson just freely said, hey, I want to plead guilty, Scientology might have said, hey, we have something to say about that. We're not so cool with that, with you pleading guilty, So that to me paints a picture. That paints a picture to me of a situation where, as far as I can tell, I don't see I don't see his counsel as being entirely free of conflict. Okay. And so, that right there tells me there's an issue. Maybe not for an appeal. Appeal is different. Um, the issue of conflict-free counsel, that has to do with effective assistance of counsel. Okay. And that's not grounds for an appeal. That's grounds for post-conviction relief, which is at the trial level, not appellate level. Okay. So basically, that would be at the very same trial court. Danny would file a motion to set aside his conviction under the California Penal Code. I think it's 1018. But that's at the trial level. That's a set aside based on that's under the post conviction relief scheme, which one of the grounds for that is ineffective assistance of counsel. Okay, so that's separate from the appeal. The appeal is going to another court, higher court, and that's just a different scheme that they don't handle directly the issue of ineffective assistance of counsel. Okay, so now, as far as like any grounds to actually like say appeal the case, okay, that would be more as to like whether mistakes were made by the trial court in terms of the handling of evidence, whether it was a defect in the actual proceeding of the trial. Okay. Now, actually, having thought about it, I do think that there is at least one good grounds for appeal, which is there was no toxicology to support the victim's allegations that they were drugged. Okay, so basically, it's a convicted fact. It's a fact of conviction. Now it's a fact of conviction. It's taken as a fact by the court that there was drugging, that the victims were drugged before they were victimized. Okay. Now, all this has been determined by the court without an ounce of toxicology. Okay. And this is concerning stuff that happened well over 10 years ago. Okay. So that is a problem. All right. And I think in the earlier trial, the court did not allow that evidence because she said the lack of toxicology makes that too inherently unreliable. And that would be too prejudicial, to have any talk of that if we don't have any toxicology to back it up. And also, think about it. If the victims felt drowsy and they felt like they might have been drugged, who's to say that they weren't just given alcohol? And do we really want to say that if they were given extra alcohol that they were really drugged? I mean, between you and me, maybe he did drug them. I'm not saying he didn't, and probably most likely he did. But I'm saying as far as like determining this as a matter of fact in a court of law, okay, I do think there's an issue that there's no toxicology and that all we have is the corroborating, coordinated statements of the victims. Okay, because that's a lot of fact finding to be laid just on the word of the memory of the victims. Okay, so hey, that could be grounds for an appeal. The judge changed her mind in the second trial and actually decided that the evidence would go in after earlier saying it was not reliable. So who's to say, maybe a federal court, maybe an appellate court, an intermediate appellate court in California could determine that, that wasn't actually reliable evidence and that any probative value of that evidence was far outweighed by the extreme prejudicial value. Okay. So whenever, there's a balancing in American courts, it's the probative value versus the prejudicial value. And because that's such a prejudicial fact that they may or may not have been drugged, these victims. And I'm not saying they weren't. They may have been. Okay, so let's just be honest. Maybe they were, but I'm just saying what counts as adequate evidence in a court of law against the prejudicial effect of that kind of evidence. And I would say that's probably a pretty good grounds for an appeal. I'm not saying he's going to win that appeal because there's a lot of leeway. Okay, judges have a lot of leeway. And a court will not reverse a judge's decision unless they're far outside of that leeway. Okay, and so it'll just depend on what judges he gets on his appellate panel. At the intermediate appellate panel level, okay, at the intermediate appellate court level in California, I believe the panels are 3-judge panels. Okay, so you'll have 3 judges, and it just depends on which judges sit on his appellate panel. And so we're talking about the actual appeal, okay? But if he loses his appeal, okay, once he loses the appeal and the judgment is finalized after appeal, okay, then he can file the motion for post-conviction relief at the trial court level. And I think he may have grounds to argue that his counsel was not free of conflict. Okay, and then he'll have to argue if they made him sign a waiver of his Sixth Amendment right to conflict-free counsel. Okay, if he signed any kind of waiver, he'll have to argue, I believe, that he didn't have a meaningful choice because of his involvement in Scientology. So right there, we see that Danny potentially could actually get adverse to Scientology in this litigation, like years down the road. Okay, but then you have to ask, like, was he given good advice? Did his attorneys, were they so full of conflict that they didn't press on him at repeated points in this litigation? Because he had years and years and different critical strategic points where he could have offered a plea bargain, okay, and probably could have just done, like, say, 2 or 3 or 4 years of prison. And so you have to ask, like, did his attorneys really press on him how he had the opportunity, okay, to avoid a lot of prison time by just pleading guilty under a bargain where maybe he could have done like 2 or 3 years and maybe some heavy probation, to follow that, And so I don't know the answer to that, but I would say, it strikes me that because his attorneys were so interconnected and so coordinated with Scientology's attorneys, okay, and because Scientology probably didn't want him to plead guilty because that would make them look bad, okay. You really have to ask the question whether he really got the best advice from his attorneys, or if maybe he did get that advice from his attorneys. Maybe Danny Masterson just told them, "Hey, look, I want to take the risk. I want to risk my entire life, basically, because I think we can win." And I think, I think maybe a better attorney, maybe an attorney that wasn't so tied up with Scientology, might have said, "You know what, Danny, you can do what you want to do, but let me tell you something, you could lose this case." And I wonder if his attorneys said that to him. Okay. And I think that's in my opinion, one of the problems, I think, with really high dollar millionaire attorneys, these fancy, like almost celebrity attorneys. They don't like to give the full portfolio of possibilities, because if they say, "Hey, you really could lose this case," then this millionaire Danny Masterson is going to say, "Hey, what kind of lawyer are you telling me that I could lose this case? That must mean that you're not a very good lawyer." And so basically, I think when you're representing really, really high dollar clients, really VIP celebrity clients, I think you almost have a pressure not to be able to give them the full menu of what really could happen to them, because part of that would make you look bad as an attorney. And so because you're so concerned about not looking weak to your millionaire client, you don't really give them the full scope of what they're facing so they can make a meaningful decision. You know what I mean? So I wonder if maybe his attorneys felt pressure because they themselves are also like VIP attorneys. It would make them look really weak and really impotent to tell him, "Hey, Danny, you could really lose this case." Okay. And I guess maybe, that's just one of the problems with the economics of high dollar representation, high dollar defense lawyering, is that you really don't want to look weak. But I think, maybe a better attorney would have told him, "Look, we're going to fight this thing. We're going to fight this thing. We have so many ways that we could win this. Okay. However, okay, also consider that we could lose. Okay. And even if we could eventually win on appeal, you could end up doing 6 or 7 years of prison time. Okay. So just understand that part of our job as attorneys is that we could also get you a wonderful plea bargain, because we're so good. We could negotiate something really, really soft where maybe you do 2 years of prison time. And in the end, that might be good for you, because you'll get this off your back, and you can even rehabilitate your image. You can even publicly apologize. And you have all this opportunity to continue your life, And I think maybe a better attorney, your attorney can't tell a client what to do. Okay. But I think a better attorney would have pressed on him and said, "Look, Danny, I want you to think about this. Okay. You don't have to do this. It's your decision. But as your attorney, I want you to think, what would it look like if you did 2 or 3 years of prison, maybe with some extensive probation, but that you could rehab your image, you could do a public apology, you could save your reputation, and you could avoid potentially spending more than 25 years to your whole life in prison." Okay, basically. And I wonder if the attorneys really pressed on him. And then my second question is, maybe part of that not just the VIP status of the attorneys where they don't want to look bad, okay, but maybe it's because Scientology also had something to say about it. And they were coordinating between Scientology counsel and Danny's counsel. And then the question is, did Danny have conflict-free representation? Okay, and if he didn't have really conflict-free representation, well, then what that tells me is that eventually we're going to see, possibly after, let's say he loses his appeal, we may see a motion for post-conviction relief under the Florida Criminal Code and the penal. I think it's the Penal Code. I have it written down. Hold on. It's the California. Sorry, it's the California. What is it called? It is Penal Code 1018. So you guys can look it up. It's California Penal Code 1018, post-conviction relief. After he loses his appeal, he could get new counsel. Okay, he could get post-conviction counsel, and they could file a motion, to set aside his conviction based on the fact that he didn't really have truly independent counsel. Okay, so I'm just leaving that out there, and also just reminding everybody that yes, I do find a problem with somebody who commits a crime like, say, or domestic violence or domestic intimate partner sexual abuse. Okay, I have a problem with that person getting a life sentence or a 30-year sentence, only because it's not because I don't think it's a serious crime. It's only because people that are convicted of second degree murder often do about 15 years. In other words, it's kind of the same scale where Danny Masterson was also subject to a 15-year, basically 15 years and up. So basically he was subject to a sentencing scheme that was equal to the sentencing scheme for somebody who commits second degree murder. Okay, do we really want that kind of sexual crime that Danny committed? Okay, knowing, let's say, taking it as true, everything that he's been convicted of, if we take it as true, do we really want that to be punished at the exact same level of somebody who's guilty of second degree murder? Okay, I mean, hey, we are a democracy. If that's what people want, if people really believe that committing that kind of intimate partner sexual abuse is the same thing as killing somebody under second degree murder, if we think that's equal severity, well, then let the majority say so. Okay, but I sometimes wonder if the majority has had a chance to meaningfully tell the legislatures that that's how they want it. And so I have to question for now whether that legislation and that sentencing scheme really reflects what the majority of people think. If the majority of people think that's okay, well, hey, it's democracy, right? But I just put it out there, like, I wonder if we really want to. There may be certain sexual crimes that do deserve to be put right at the level of second degree murder, but I would think that would be more, let's say, abusing minors, or maybe much more violence in the commission of the sexual abuse or whatever. And so I just put it out there, But basically, in this video, basically, I'm saying that I think Danny and his attorneys had a lot to do with the sentence being so high, because they had plenty of opportunities along the road to either make better arguments for mitigation or to actually plea bargain this case. Okay, and maybe get him off with a very, very small amount of prison time. So, you have to ask, why didn't he do a plea bargain? Was it just Danny being stubborn, or maybe his attorneys didn't fully press on him how weak his case may have been? Taking the risk, right? If you're an attorney, you tell a VIP client that you could lose, he's liable to fire you as an attorney. Like, what kind of attorney are you telling me that? So it's a delicate game, but maybe a good attorney knows how to do that. It's kind of like, the dog whisperer. You have to be able to whisper, to really VIP people and really tell them what's what, So you have to wonder whether he got maybe the best representation. And that could be another dimension of the ineffective assistance also. Like, Danny could argue that he was never presented with a realistic assessment of how weak his case was, never presented with that, and never presented with the option of plea bargaining. If that's true, well, that's another argument for ineffective assistance. So there's a lot of dimensions here. And, there's the Scientology being involved in the defense, which I think questions whether he had conflict-free counsel. And then also, did he get a serious talk from his attorney as to the benefits of a plea bargain? And if that's not true, well, there's a lot out there that potentially could be grounds for a motion for post-conviction relief, assuming he loses his appeal. So, it's not a good position. And, if I was a defense attorney on the team, my main question would be, did we fully press on Danny the options and the realities of maybe offering a plea agreement, and then secondly, would Scientology have not been into that? And would there have been a conflict between the Scientology side of the defense and Danny's side of the defense? And would Scientology maybe have dominated and sort of suppressed maybe a potential decision to do a plea bargain? So there's a lot going on there, and I think the field is rich, maybe not so much for the appeal, but for post-conviction relief, assuming he loses the appeal. So just things to think about. And also just to understand that he didn't really have to have such a long sentence. His own defense team and he himself, Danny, had a lot to do with why he got such a high sentence. So I'm putting that out there too. Anyway, thanks for watching.